Hi, everyone. Thank you once again for joining us. So, like I said earlier, I'm Tracy Mensah. I work with the Ghana Netherlands Business and Culture Council with the Dutch Chamber of Commerce in Ghana. And we basically facilitate trade between Ghana and the Netherlands. We're a membership organization, so we have members that cut across various sectors in Ghana. And we also run several projects in partnership with the Netherlands Embassy to strengthen the private sector so yes, I want to say thank you again for joining us. And I see Sairam already said hi in the chat. So for all who haven't, please say hi in the chat. Let us know who you are and where you're joining us from so that we can all interact. I'm happy to moderate this session. And the topic of wills and estate planning is very crucial. It's a very important conversation that has to be had, especially in Ghana. So we are happy to bring this to you. We are bringing on board an expert who is from GNBCC's membership organization. The company is Ntrakwah Co, and we have Nana Yaw Ntrakwah, who would be taking us through this session. Before we officially begin, I would briefly read a short profile about Nana Yaw, and then I would give you the floor to continue. So Nana Yaw is a lawyer with over 17 years of experience. He is a partner at Ntrakwah Co. He's a full-service law, Ntrakwah Co is a full-service law firm, which was established 41 years ago. That is very long, by the late Felix Ntrakwah, and is currently being run and managed by the second generation. Nana Yaw is a member of the Honorable Society of the Middle Temple, London, a senior fellow of Litigation Council of America, and a member of the Ghana Bar Association. He holds a BA, LLB, PG, DIP in law, and an LLM. He is currently a director of the Royal Saintchi Limited and is a board chairman of Overseas Warehouse Ghana Limited. Nana Yaw has trained several boards on corporate governance. He's a guest lecturer at the Ghana School of Law and faculties of some universities in Ghana. So Nana Yaw, thank you very much for joining us. We are happy to hear from you. Before I give you the floor, I would want to go over a few housekeeping rules so that we can have a seamless webinar. So kindly ensure that your microphones are muted at all times so as to not disrupt our speaker. At the end of the session, we'll have a Q&A. So if you have any questions, you would be allowed to ask. Whilst he's doing the presentation, you're welcome to leave your questions in the chat box, and then we'll read all of that out during the Q&A session. And this is not mandatory, but we would also invite all who are comfortable to turn your cameras on so that it's a bit more interactive. So thank you all. And also lastly, the session is being recorded. So just so you know, for everyone. All right. Thank you all for joining us. I will stop talking now and welcome Nana Yaw Ntrakwah to do maybe a bit more justice to the introduction I did about him, and then also start with the presentation. Thank you.
Good morning, everyone. I hope you can all hear me loud and clear.
Yes.
Good. Thank you very much for those wonderful words. I think you've done enough. So I'll proceed with the webinar. Let me share my screen here. Good. Can we all see the screen?
Yes, we can see.
Good. Just a moment here. Okay, so I'd like to start with some rhetorical questions. What would you do if you were willed millions of dollars? These days, we know that we should be careful with dollars. Otherwise, you will get the name, your name and dollar attached to it. But all the same, how would you go about claiming it? If you are appointed an executor, how do you go about it? if you leave this earth without making a will, what happens? Well, hopefully, if we've thought about estate planning, we will have some answers.
Nana Yaw,
Estate,
sorry to interrupt.
yes.
Yes, can you kindly put it in presentation mode so that it's a bit broader?
Yeah, I have a challenge at the moment. When I put it in presentation mode, it goes off for some reason. I'm not
Oh,
sure what it
okay.
is. So pardon me, and yeah, we'll
Yes,
go.
we'll make do with this.
Yes,
Thank you.
yes, yes. Thank you. So when we talk about estate planning, it is generally described as the process of anticipating and arranging for the management and distribution of a person's estate during a person's lifetime in preparation for future incapacity or death. So these two are important. You're not only preparing for death, but future incapacity. How do you prepare for this? Well, we know that people have used trust, like setting up a trust, company, or setting up a trust made of individual trustees. People use a power of attorney. I believe we all know what a power of attorney is or have heard of it. Or let me say, a power of attorney is simply, giving your decision-making powers to somebody in the form of a document. I'm trying not to make this a law course, so I'll avoid terminologies as much as I can. And also, if I may say at this point, that this is not intended to be legal advice. If you need legal advice, so you can talk to a lawyer. Okay. Now, funeral and burial instructions is one, other means where people, plan their estate. I think this is quite important these days in Ghana, and quite a number of people are doing this funeral and burial instructions. As some of you may know, I have been through the process of losing my dad not long ago, and it's one of the inspirations for speaking about wills and estate planning at this stage. So many demands are made when you lose a loved one. You'll be amazed what comes up. So you find that increasingly people are stating what they want to be done to their body when they are no longer with us. The funeral arrangements, the number of months they should be at the mortuary before, they are buried, and all manner of things. And this is quite crucial. Now, we have what we call a living will. And a living will essentially is a document that you state what needs to happen to you or what you want to happen to you in case of incapacity. Maybe you have a health challenge, and you cannot talk or something. So before this, you encounter this challenge, you write down what you want to happen, the decisions you want to be made if you have a health challenge. So it's some call it the living will. Then we have a will, properly so called, which is the main focus of today's discussion. We are singling out wills for today to talk about estate planning. Now, I have been introduced already. I'll skip this page. But then I'd like to throw more light on what I have done with respect to wills. I've challenged wills in court. I've acted as a lawyer for beneficiaries of a will, acted as a lawyer for executors of a will. I've drafted wills, provided legal advice. I'm currently an executor managing and distributing an estate. I've also been a beneficiary of a will. So essentially, I have tasted from all these, fruits, if I can put it that way. The agenda for today, we'll be looking at some myths surrounding wills. We'll talk about some wills in detail. We'll look at the legal requirements of a will, steps to writing a will, and also how an estate is administered, time permitting. What are some of the myths surrounding a will? The most common one is the belief that only wealthy people need a will. Clearly, that is a misconception if you know what is happening these days. Now, having a will is beneficial for everyone as it ensures that one's wishes are known and respected. A will provides clarity and reduces confusion for loved ones during difficult times, regardless of wealth. So you don't need to be given millions of dollars before you make a will. Now, another myth is that making a will means you are about to die. Some people believe that making a will marks the beginning of their end, but this is often a misunderstanding of its purpose. Genuinely, talking about death is sometimes considered a taboo in this country, in this part of the world. Confronting one's mortality is also very uncomfortable. But putting your affairs in order is one of the kindest things you can do for your family. My personal experience, I have drafted wills on so many times for people. But when I sat down to draft my own will, I was kind of faced with something. I'm not sure what it is, but I had to ask myself, what are you doing? Is this the beginning of the end? Do you think you are going to die? So I can understand that it is not easy overcoming the psychological preparation to sit down and plan or write about your death. It's not easy, even for me, who had, done it on a number of occasions for others. When I sat down to do mine, it wasn't easy psychologically. But I look at the end, and then I did it. So just so you know, this is not a case of why is the lotto doctor not rich. I have drafted my will, so I encourage you to do so. And I'm not a millionaire yet. Soon though. Now, another myth is that some believe that when they pass away, their spouse automatically inherits everything. So there's no need to do a will. That's, however, not the case. If you die without leaving a will, intestacy law will apply. In some cases, customary law may also be applied. Intestacy law will go into it a little bit, more. Customary law essentially is the custom that's in place from, one community to the other. It may be upheld. I remember when we were planning my father's funeral, at a point in time, I was called by some of the elders and they told me, hey, behave yourself. If you do not behave yourself, when we share your father's property, we will not give you some. So I said to myself, what do these people, who do these people think they are talking to? I know my rights, but I kept quiet and then I moved on. So customary law could be unpredictable For a start, it's not even written anywhere for you to cross-check. It could be based on, the customs, rather. It could be based on somebody's, imagination, and then you have to comply. So, what is the alternative to having a will? As I mentioned, intestacy law can apply. In Ghana, we have the intestate succession law, 1985 PNDC law 111. So if you die without making a will, you are said to have died intestate. And this law will kick in to save the situation. So if you look at the history of this law in the past, or even currently, as it still pertains, when somebody passes away, especially where it has to do with a widow, the extended family comes to the house and then kicks you out. There's one instance where they said, according to their custom, if you're a married woman, when your husband dies, you must leave the house according to custom. So you see that PNDC law 111 came in to protect spouses, for example, in a situation like this. So the law says that you cannot be kicked out of the house when your spouse passes away. Most importantly, and to draw the distinction between having a will and not having one, under a will, you are able to distribute all of your property. I'm taking, for example, a house. You can state, if you have 10 houses, you can state that all the 10 should go to your spouse, to your children, or to whomever. Now, if you do not make a will and PNDC law 111 kicks in, PNDC law 111 limits the distribution of the house, of one house, to the spouse. So, for example, if you own 3 houses, or an example, if you own 2 houses and you die without making a will, the law says that the spouse will get one. The rest will go into what is called the residue. Everything else. Okay. So I'm using this to demonstrate why it is important for you to write a will. With a will, you get the opportunity to state how you want your assets or your property to be distributed. As against not making a will, PNDC law 111 kicks in. I'm not saying that PNDC law 111 is necessarily bad. It came to cure a problem. But you have more control if you make a will. Now, in the absence of a will and PNDC law, by law, 111 is supposed to kick in if you have if you die intestate. But in practice, people also ignore 111 and do customary distribution, which I have mentioned can be arbitrary. If they are doing some form of distribution in accordance to customary law, it will be better than a loot and share. That may happen. There are also some instances where, everything will be abandoned. Now, there's this thing on social media now where we are shown pictures of an abandoned estate of a rich man, and I look at it and there were about 10, 12 Mercedes-Benz S-Class abandoned in the basement of a vehicle. Now, after all the toil and hard work, would you want it to be left to rot? Well, we don't know what the exact circumstances in that Nigerian case, but it's just, a wake-up call. Now, let me dive into wills properly. What is a will? A will is a legal document that sets out how a person wants his property, assets, estate to be distributed after their death. So by property, we are talking about houses, money, cars, clothes, etc. Now, the people who are going to benefit from the property you are distributing are called beneficiaries. Now, the will can specify those who will receive the assets and property according to the individual's wishes. As we have mentioned, you lose this flexibility to state who should receive your property upon death if you do not make a will. Now, wills include instructions on how to distribute assets, ensuring that specific wishes are honored after death. So essentially, that is an idea of what a will is. Why is a will important? I've already touched on a few, but a will ensures that your final wishes about your properties are respected and carried out after your death. Having a will can minimize conflicts among family members regarding inheritance and estate management. A will provides clear instructions for managing your estate, ensuring smooth transitions for your heirs. Now, the legal requirements for writing a will in Ghana. I'm touching on this because by law, the will not necessarily need to be drafted by a lawyer. In other jurisdictions like the UK, they have what they call the wills pack. These days, AI, artificial intelligence, can even draft a will for you. I caution you, however. But yeah, if you get a wills pack, it tells you where to insert the assets and name the beneficiaries and all of that. The will pack will also come compliant with the law of UK if for example you are buying it from the UK. But in Ghana, any person of 18 years and above and of sound mind can legally write a will. The reason why you must be of sound mind is that we want to ensure that you actually understand the implications of what you are doing, and that you actually intend to give these properties to the beneficiaries. The will must be in writing. Now, the property must be the testator's, that's the person making the will. It must be the testator's self-acquired property, or property the testator will be entitled to at the time of death or thereafter. So let me explain the last two that you'll be entitled to at the time of death. So, for example, somebody has willed you millions of dollars. It is not yet vested in you. It's not yet, in your account. So you will be entitled to. So you can put that down in your will. Okay. So we'll talk about witnesses. Now, witnesses are important to writing a will. Having witnesses present is essential for validating that the testator signed the will. The signing of a will by a testator must take place in front of at least two witnesses, and this is key. Two witnesses who must be present at the same time and also sign the will. So the witnesses must be present at the same time. If they are not, you create problems, or you create an avenue for a person to challenge the validity of the will. And it is very easy for me to determine under cross-examination whether the two witnesses were present at the same time or not. How I determine it is a trade secret, so I will not share it here. Now, testator's signature must be at the end of the text, must be at the end of whatever you have written. Any text after the signature will not be considered as part of the will. So if your signature is at the middle of the page and you have made some dispositions after the signature, it will not be considered as part of the will. So when you are writing your own will, you must bear these things in mind, these legal requirements. Otherwise, your will be challenged and it will be held to be invalid. Now, a beneficiary cannot be a witness. I've explained that the beneficiary is the one receiving or being given the property. So the beneficiary of the will cannot be a witness to the will. If this happens, the beneficiary will be excluded from the will. So the story is told of, and pardon me, I'm doing this without prejudice to anybody's rights or feelings, but the story is told of a man who wanted to punish the wife. The wife was insisting that the man, makes a will and gives all the property to her. So the man says, okay, no problem, I'll do it for you. The man does the will and calls the wife, hey, come and sign here as as a witness. And at the end of the day, the wife could not benefit from the will based on the legal technicality. So, moving on, yes, blind or illiterate testators can make a will. A competent person must, however, read and explain the contents of the will to them before it is signed. The will must include a statement saying that the contents were read to the testator in the language they understand and that they appear to perfectly understand. Yeah, just a second. Now, after you have written your will, or after a will is written, it is important that you update it regularly. You update it to ensure that it reflects your current circumstances and your wishes. So consider changes like marriage, divorce, heartbreak, or new beneficiaries. Now, if you, well, I'll say the story at a later time. Now, safe storage. Store your will in a secure location to prevent loss or unauthorized access. Ensure it is easily accessible when needed by your loved ones. So a will is a confidential document. Store it properly, safely. Not even the executors need to know the content of the will. All they need to know is the fact that they have been appointed executors. I'll talk about executors later. These are the people you have appointed to administer or to share the property in accordance with your wishes. Now, you may deposit the will at the High Court for safekeeping. This is standard practice. So that in the event that you are called to glory, a search can be done at the High Court and then a copy of the will be obtained. Now, if somebody makes a will, if you come across a will which has not been deposited, then by law, you are mandated to deposit the will within 14 days that you come across it. Now, changes to the will are accepted only if made in a separate document following the same process. So if you want to make a change to your will, you can draft a completely new will and say that you are revoking your previous will in the content. Or you can do what is called a codicil. That's a legal terminology, but basically it's another document that is acceptable or accepted to be able to make changes to or update the content of a previous will. So if you have a codicil, it will mean that you have two documents, the will, original will, and the codicil making changes to the original will. You have two documents. But if you update it by writing a new will, then you only have one document. So that's the difference. Now, steps to writing a will. Come up with a list of your assets and your beneficiaries. Start by compiling a detailed list of all your assets, including property, investments, and personal belongings. Determine who you would like to inherit your assets. This can include family, friends, or charitable organizations. Now, you have to determine how you want the property to be shared. So if it's land, a landed property, for example, we are looking at either it's going to be joint tenants or what we call tenants in common. Now, if we are talking about joint tenants, there's a right of survivorship, which essentially means that when one person dies, the survivor takes everything. Then the other version, that's the tenants in common. When one person dies, you know, the people inheriting from the dead person can still claim that aspect of the property. Can decide whether you are giving, money in equal shares, money in your bank account in equal shares or in percentages. You are flexible on how you want to distribute it. Now, ensure that your will is written in clear language to prevent misunderstandings and disputes among beneficiaries. Include detailed information about your assets and wishes to provide a comprehensive guide for your executors. If you say something like land at airport, clearly is not sufficient detail enough for even the executors to identify which property you are talking about. Now, avoid ambiguous language. This can lead to disputes. Therefore, be specific in your instructions to safeguard your intentions. Now, have a residuary clause and be mindful of who gets it. The residue in respect of a will is, let's say you've given out a few properties you've given up some properties, but not all of them. If you do not dispose of the property in the will, it will fall into residue. So the residue actually is a safe net that captures properties that you have not distributed specifically in your will. Now, if you don't have a residuary clause, then it will fall into intestacy. So the residue, as the remaining part of the property that has not been specifically disposed of, will be caught or will be saved by the residuary clause. Now, again, the story is told of one person who wanted to punish the son. And after distributing the property to everybody, knowing that he had nothing else to give, said, all that is remaining that I have not already disposed of, I give to my son, thinking that he had punished the son because he knew he had nothing else. But Along the line before his death, he acquired more properties and he did not update the will. So when the good Lord called him and he went to be with the good Lord, the new properties he had acquired, which was of much value or better value than the previous ones, all ended up being with the son. So lesson, update your will. Have a residue or a residual clause, but be mindful of who gets the residue. It is not a place to punish people. Otherwise, you end up punishing yourself. Okay, let's talk about executors. The executor is somebody you trust to follow your wishes and to carry out your instructions. There's no specific qualification to be an executor. All that is required is that the executor is 21 years and above. So unlike the will, where any person above 18 years can make a will, for an executor, the person must be 21 years and above. Ensure that the chosen executor is willing to accept the responsibilities associated with executing your will and managing your estate. Don't just pick anybody. Pick a trusted person, somebody who has, I would say, the muscle or the will to go the full haul when it comes to administering your estate. Let the person know that the person has been appointed executor. As I mentioned earlier, you need not disclose the contents of the will to the person, but it is important that the person knows that he or she has been appointed executor, so that when the time comes, he or she can approach the family and say, oh, I know that, this man, this woman made a will. So let's go and look for it. Now, the executor should have a clear understanding of their duties to ensure that they can effectively manage the estate's affairs. What are their typical duties? We look at they are required to gather the estate, that is to look for the assets that have been, listed, and then pay the debts, any debts, then distribute the estate in accordance with the will. I've provided a sample will just so that we can have a look. I'm not sure how well we can all see it, but this is, a simple, sample will. We have, we have beneficiaries, we have executors, we have properties that are being given, and we can see that it has been signed by the testator and then also signed by the two witnesses. And as I mentioned, you must ensure that the two witnesses are present at the same time. Again, the witnesses need not know the content of the will. They are simply attesting to the fact that you signed or you signed your will in their presence. How an estate is administered. After you've made the will, you are called to glory. What happens? We have to find a will. So then, as I mentioned, you must let the executors know that they have been appointed executors. So they have the duty to find a will, includes conducting a search to find out if a will has been deposited. If a will has been deposited in court, then you write a letter for the will to be read. If the will has not been deposited in court, then you have a duty to go and deposit it in court for it to be read. Now, after the will has been read, the executors will apply for what we call probate. Essentially, they are applying for the authority to distribute the assets. So what is typically required is a death certificate. And when you are applying for probate, you go to court. So unless you are skilled in advocacy, it will be good to hire a lawyer to apply for probate. Although, an executor can go and represent him or herself in court and apply for probate. There will be filing fees involved, and then you have to pay estate duty. So if I can call it a form of a tax, but estate duty, which is 3%, I believe it is currently. And then we have just a second. Yes. So after you apply and obtain probate, the probate certificate is issued to you. And this is when you can now start distributing the asset, that is the executor. You are not allowed to distribute the asset if you do not have the certificate. I believe that brings us to the end of my presentation. In conclusion, I would like to say that creating a will is essential for ensuring your wishes are honored after you pass away. There are many myths surrounding the process of writing a will. It is crucial to debunk these myths to make informed decisions. If after you've considered all the options and you still think you will not make a will, that's fine. That's your decision. Now, familiarize yourself with the legal aspects of writing a will, as it's important to ensure its validity and enforceability. Now, in conclusion, I'd like to say that a well-drafted will can help provide for your loved ones, ensuring their financial security and peace of mind. So thank you for listening, and I hand over to Tracy.
Thank you very much, Nana. Very detailed. We really appreciate it. And I think we can all really much appreciate it, especially because of the stories we hear surrounding wills or people dying without wills. And even if you've not heard stories, some of us might have experienced it ourselves. So it's good to know this and that we can take the necessary steps. And also, thank you very much for debunking the myths. So you do not have to wait until you're extremely wealthy. It's not reserved for just the wealthy. And preparing a will does not mean you are dying, right? So don't wait until you're about to die or you're ill, and then you can look at it. Look at it as soon as you can so that your loved ones are covered after your death. So we have a few questions in the chat room. I would go through them and then ask. I wanted to first start with this. What happens to the residue once if concerning the interstate succession law, so what happens to the items that go into the residue?
What happens to the items that go into residue? So a well-drafted residual clause will name who should get the residue. So it is important that you name who gets it. And as I mentioned, it's not a place to punish people. You may not know what you may acquire later on. So whoever you put there must be somebody you want to actually inherit. It's a safety net.
So in the case where you don't have that clause in your will, what happens to it?
Can you say that again?
I'm asking that in the case where you don't have that clause in your will, what happens to the rest of your products that were not accounted for in your
Right.
will?
So it falls into intestacy. So it will be deemed that you died without making a will in respect of those properties. So then you have to apply for letters of administration to be able to deal with those properties.
Right. Okay. So D is asking what happens if the beneficiary dies. And yeah, so both the beneficiary and then the executor, in instances that they die before the will is read, what would happen?
All right. So we take it from the executor's point of view. There's what we call the chain of succession in dealing with executors. So if an executor dies before the will is read, and I mean, obviously the testator is also gone, then the one who succeeds the executor, the executor's executor becomes the executor. I don't know if it's clear enough. Okay, so that's in dealing with the executor's aspect of it. If the executor dies and the testator or the person making the will is alive, then the person can update the will to, appoint a new executor. Some people appoint two executors so that if one person passes away, the other executor can also, take over and administer the estate. In terms of the beneficiary, if the person dies, then it lapses. So then it falls into residue.
Hmm. Okay. Another question. What if the beneficiary okay, this question is what if the beneficiary being a witness does not know that they are a beneficiary? Is that any case where that can happen?
It can happen, but the law is clear. You will not get it. Yes.
Right. Okay. All right. There's also another question. Yeah, so are your inheritance taxed? Nana, did you get that question?
Can you say that again? It's about inheritance tax, right?
Yeah, are they taxed?
Yeah, so what we say, you pay estate duty at the time of applying for probate. But that inheritance tax, properly so called, we don't have that. But
Okay.
you will pay estate duty at the time you are applying for probate. So you will list the executors will list the assets, you know, and then based on the value, estimated value, you will be charged the estate duty. Now, if, for example, I mean, you get a vesting assent or you go to a bank with a probate certificate and they realize that you have understated the value, they will send you back to the court to pay the difference. When you go back, when you are applying for probate, when the judge realizes that you have also understated the value, the judge may also ask you to state a more, a proper value for the estate duty to be, applied.
Okay. And how about properties abroad? So the question was surrounding inheritance tax, but since you've clarified that, um, with properties abroad, do they have different duties as compared to properties in Ghana?
Properties abroad. Hmm. If the property is abroad, I mean, in terms of applying for probate, you estimate the value and then estate duty will be applied. But since the property is abroad and it will not be administered in Ghana, we have something called sealing of probate. So if the jurisdiction, if the country or the place where you are allows for sealing of probate, then they will accept the probate that has been granted here over there. So the reverse is also true for Ghana. If you are outside Ghana but have properties in
Yes, am I
Ghana.
able to make it?
Can you hear me?
Yes, yes, I can hear you.
Okay. And you have properties in Ghana, you can either make two separate wills, one covering the property abroad and the other covering the property in Ghana. Or once you make the will covering the property abroad, you can come to Ghana after you've been granted probate and ask for what we call sealing of probate. So essentially, you are bringing the certificate you have there here for the court to accept it, so that you can administer the properties in this jurisdiction in Ghana.
Okay, thank you. So to the next question, can an inherited property be willed to someone else?
Yes, if you have, if it's been given to you, so by inherited, I mean, I'm assuming that the right processes have been done for it to be vested in you. Yes.
Okay, so could you kindly tell what happens in the situation a person died interstate, but has only one house and is in debt?
Well, that's legal advice. Okay. All right. So a person, wow. Hmm. That's an interesting one. By law, it goes to that one property the spouse will be entitled to. Okay, but if the creditors come after you, it will be no excuse to say that you know you don't owe, because you are required to pay the debt as well.
Mm.
So you have to find a way of doing it. You either borrow to satisfy the debt, you will rent the property to satisfy the debt, or you can decide otherwise.
Okay. And can a person give everything to one person? Can the will be directed to only one person, everything?
Yes, you can, but the law allows certain people to go to court to ask for a reasonable share of the estate. So wife and children under 18 years, for example. So if you make a will to one person who, and it's not any of these two, they can apply to court for them to be given a reasonable provision from the estate.
Jeffrey is asking, are trusts used as vehicles for inheritance in Ghana?
Yes, yes, yes. Trusts are in Ghana. At a point in time, we got so many requests for trusts to be created. So yes, trusts are in Ghana.
Okay. I think these are the questions we have for now. Please, we are having our Q&A sessions. So if there are any questions, kindly drop them in the chat room and then I'll ask. Okay. There's another question. I think the question is coming from Dia. It's funny, but what if I am named as an executor, but I am unwilling to serve?
Please say that again.
So what if a person is named as an executor, but the person is unwilling to serve?
Oh, yeah. Okay. Yeah, you can go and renounce probate. And then the court will appoint the administrator. The court can appoint the administrator general to administer the estate. So yes, you can renounce. That is, say you do not want to be an executor.
And in the case of a trust, is the property tax 3%?
No, the trust is a bit different from the will. So actually, it is different from creating the will. Although you can use a will to create a trust, the trust is different. So the 3% will not be what will be applicable.
Okay. I see Pastor Entry is trying to ask a question, but it's not clear. So kindly rewrite your question so that we can all we can ask that. And how the trust operates. Saki is asking this.
All right, this is outside the scope, but I'll still answer it. But how do trusts operate? So somebody can say that I'm giving my legal interest in this property to another person to hold in what we call the legal interest and the beneficial interest. So when the legal interest moves from you to another person to hold in trust for you, you create a trust. Because it's a completely different topic, I don't want to go too much into details. There are so many other instances where a trust can also arise. So, for example, if you contribute to the if you pay the purchase price of property, for example, for land, you can make the case of a trust, a resulting trust in your favor. Again, I don't want to go into too much legalities, so I'll end it there.
Yes. Jeffrey, we will either look at the possibility of setting up a webinar on trusts, or we would leave Nana Yaw's details so you can go for legal advice on trusts. Yes. Pastor Entry Malik is asking, is it allowed to will to a beast in Ghana? I think he means like, yeah, a beast, probably an animal, unless I'm wrong. Please clarify. Is that in Ghana?
No, 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 no.
Ambassador Appiah says you're referring more to a man writing a will. What if the spouse, so in this case a wife, passes and the husband was not appropriately catered for in her estate? What does the law say for men?
So the term is spouse, so it will apply either way. But just so I missed one point I wanted to make, that it appears um women are not comfortable or are not interested in making wills. If you look at the statistics, it is the men who most often make wills. And typically, women say that, oh, I don't own anything to make a will. But I will advise that once you have kids, and because the law provides for what you own, your personal property, including what you may get, you have to make provision, because we've seen instances where, um, you know, the men are leaving us, or let's say even no, rather the women are leaving without making a will, and there's a battle between the husband and the extended family. If you leave a will, you avoid all of these controversies.
Thank you very much for clarifying. We've exhausted our questions in the chat room, but okay, one just came through. Can a will include burial and funeral instructions? How would the bereaved know this, since wills are usually read after the burial and funeral rites?
Right. So I missed some portions because of connectivity, but I think the question is about funeral instructions, putting your funeral and burial instructions in a will.
Yes, so the
Now,
question is saying,
technically,
yeah, so it's about funeral instructions and how would you know the instructions since the wills are typically read after the funerals? Yes.
so typically or technically, a will can be read after death, right after. But the practice and the custom that exists currently is that people wait until after the burial before they talk about the will. So then I would advise you do a different document covering the funeral and burial instructions to avoid any, because even according to custom, they will not open or go and look at the properties until 1 year after. So people actually wait until 1 year after the death before they apply for probate. That is wrong, though. That's not what the law says. But this is what happens in practice.
Is there a fixed charge for writing a will? Thinking this question is in relation to if you're looking for a legal person to support. Yeah.
There isn't a fixed charge. It's typically based on the value of the estate.
Okay. And what happens when a single mother leaves everything to an only child, but dies before the child is of age?
So what happens when a single mother wills everything? Okay. So that will mean that the person attempted to even write something. So the advice will be that if you are doing a will that involves a child, then you should look at appointing a trustee in the will who will take care of the child to save that situation. Again, you can apply for yeah, it will be ideal to appoint a trustee to to solve the situation. Otherwise, we engage in some complexities. Yeah.
Okay, I think these are the questions. We still have a few minutes, so if you still have additional questions, feel free to drop it in the chat. But I hope our questions are clarified. And okay, another question. Please, are the children of a late beneficiary entitled to the beneficiary share of a family property if the children are of age and of sound mind?
Okay, so it would depend on how the beneficiary was supposed to inherit. So if you remember, I talked about joint tenants and tenants in common. We will need to know how that beneficiary, the interest that the beneficiary got, and then that will determine. So yeah, that will determine it. So if it was a joint tenancy, then the answer would be no. If it was a tenant in common or tenancy in common, then the answer will be yes. So we'll need to look at it in detail.
Okay, thank you. I hope all our questions are clarified. If you need further clarification, kindly do so now. But I would also ask Nana Yaw to please leave your details with us in the chat so that those who have follow-up questions and questions out of the scope for we are discussing can reach out to you for legal advice. And for anyone who would like access to this recording, if you did not sign up using our Google form, kindly leave your email in the chat so that we can also forward you the recording after.
Right. So I
Okay.
have left my details, my phone number, and my email address. It's nana.yaw. Without the dot, your will be invalid. And so please pay attention to
Thank you,
it.
Nana. All right. We have, I think, a few questions that have come through. Do family members have a right to demand things if they are not included in the will?
The answer is no, if they are not. But the
And
family members are not easy to fight.
exactly. So, another question from Barnabas. What makes a will valid? Uh, I'm sorry, 1 second. Yeah, so if someone decides to write the will without a law firm, is it still valid? I think you clarified this earlier.
Yes, so long as you meet the legal requirements. I said that you need not have a lawyer write the will. But if you have a complex estate, I mean, it will be good to consult a lawyer. Yeah.
Susan is asking, in the case of foreign nationality, that is a resident in Ghana, should a will be drawn up abroad or in Ghana?
You have both options. Um, Either you do it abroad, include the properties in Ghana. So, and in that case, you have to come back to the Ghanaian court for sealing of the probate, or you have a separate will in Ghana, in which case you still have to go to a Ghanaian court, for probate. There are advantages and disadvantages in these options.
Okay. Can an administrator of a will be a beneficiary?
Okay, so we'll say an executor of a will. So that will be the appropriate terminology. Yes, the executor can be a beneficiary.
And Sasaki is asking, what happens if a child builds on her father's land, but her other siblings don't, and the father wills the entire land to another child? These are some very interesting questions.
Yeah, and it's quite interesting, and I've seen it a number of times. So you have to be clear in writing your will. You must consult. I think it would be good to consult a lawyer if you want to do something like that. Now, the problem is that, or the position of the law is that whoever owns the land owns what is on it. So that if the land has been willed to you, to what was the question? The land, the child builds on her father's land. Okay, but yeah, so whatever is on the land belongs to the person who has been willed the land. So you need to get advice before you write these kinds of. We've seen it a number of times where even in situations where you know somebody intends to will the the business but does not will, and it's a limited liability company but does not will the shares. It will be advisable to.
All right, thank you. Back to the question concerning the foreign residents in Ghana. Which one would you, is there, which one would you advise is better? Or you can, what would you say?
Um, in my office, we have, I mean, people who support both. I mean, personally, I think I will go for drafting one that is in Ghana. So you have a will in Ghana over property in Ghana. I think that will be the simplest, Because if you do it the other way around, you will still need legal advice, in applying for the sealing of the probate, and the executor there may not be familiar with the terrain, in Ghana. So it will be good to have, you know, separate ones, but there could be other considerations that will make it, practicable for you to do, you know, separate documents. Yes.
Okay. Abigail is asking, can a beneficiary prevent her late brother's children from inheriting their father's share of a family property if the father is dead?
So again, this we need to examine the documents involved. We need to know the manner in which the beneficiary inherited the property, and then we can take it from there.
Thank you very much. We are almost at the end of this webinar. I hope it's now very, very clear. And like Nana Yaw said, you're not waiting to die until you start your will. It's not for only those who are wealthy. And as much as you can, seek legal advice so that you don't do something and then find out that it can't happen in the event of your death. So thank you very much, Nana Yaw. And to everyone, please leave your email in the chat if you haven't already. And keep an eye on GNBCC social media. We'll put that in the chat room shortly. We've had, this is our third webinar so far. We had one on pensions, we had another on exports and imports, and we look forward to having more webinars in the future for the rest of the year. So please keep an eye on our social media, on our websites, and reach out to the chamber so that you can benefit from future webinars that would be had. And you're also welcome to join the chamber. As we mentioned, GNBCC is a membership organization. Ntrakwah Co is a member. I'm seeing another member, Kweku Innocent from AB Lexmal. It's also a law firm, and they're all members of GNBCC. So you're also very much welcome to sign your company up to be members of GNBCC so that you can benefit from this very rich network. Okay. So in the absence of any other questions, we want to say a very big thank you again to Ntrakwah Co for joining us, for sharing your expertise, and for even going beyond the scope of what we decided to do today. And also to our participants, thank you so much for staying with us for 1 hour, 30 minutes, and also for being very obedient to mute your mics so as to not disrupt the session. Yes, so we are done for today, and we hope to see you all again when GNBC organizes future webinars. Thank you very much, everyone. Have a good day. Bye-bye.
Bye.